Good afternoon. I'm Allison Baker. I'm chair of co-chair of Venable's Consumer Financial Services Practice and chair of Venable's Financial Services Practice. And today we are presenting Seila Law versus the CFPB, the Supreme Court decision that came out 2 days ago. As everybody knows, this decision has been one of great anticipation, and those of us on the phone have been following the colloquy around this decision, as well as carefully studying the effects of the decision that came down on Monday. And today we're going to be discussing a few things: the brief background about the decision and about the case itself and how it found its way to the Supreme Court. We're going to be discussing briefly the holding in the case, as well as some of the dissents that accompany the 105-page opinion. We're going to be talking a bit about the remedy that's contemplated in the holding of the case in terms of ratification and remanding it down to the Ninth Circuit, the lower court, the district court. We're going to be talking about some of the practical effects of the Seila Law case, both on terms of how the CFPB is going to be moving forward with respect to ongoing investigations and litigation, as well as rulemaking, supervisory, and guidance activities. And finally, we're going to speak a little bit about what you need to be thinking about next should you find yourself either being the recipient of a CID from the CFPB or otherwise dealing with another component of that agency, and how you should be thinking about it in terms of right now and going forward, especially as we are in an election year. And without further ado, I'm going to turn it over to my colleague Peter, who is going to start talking about the background of the case and how it found its way to the Supreme Court. Thank you. And before we start, I should note, if everyone could introduce themselves before they start speaking as well. We have a fantastic group today, and I'm going to let them introduce themselves to this group on the phone. Thank you.
Absolutely. Hi, everyone. This is Peter Frechette, an associate with Venable. I've put the presenter screen up for that slide so you can take a look, but as Allison said, we'll have people introducing themselves. So I think we can quickly run through that now, and then you'll see people as they pop up. But I work closely with Allison and the team on these and other consumer financial related issues. So why don't I turn it over to Andy to introduce himself, and then we can kind of run through the presenters, and then I'll quickly get into the introduction and background of this case.
Hi, so thanks everyone for tuning in today. This is Andy Arculin, a partner in the group with Venable, and also a veteran of the CFPB's Office of Regulations. I joined Venable in 2015, and my primary role at the firm is really consumer lending, and obviously a lot of interface with the CFPB in the supervisory context, the enforcement context, but also regulatory implementation and transactional work. So I'll turn it next to Jonathan.
Thanks, Andy. Jonathan Pompan here, co-chair of the Consumer Financial Services Group, and also have been following closely, of course, the question of the constitutionality of the CFPB essentially since it was created in 2011 and thereafter, and whether the companies that we've represented have had their backs against the wall because they faced a tough enforcement position, or trade associations and other interests looking for policy developments. There's always been this looming question, which of course was answered on Monday. Look forward to discussing it with everyone.
Jerry?
And hi, I'm Jerry Sachs. I am a partner in the Financial Services Group here at Venable. I am formerly with the CFPB Enforcement Office, where I worked with Allison and others, and Andy as well, when he was in the regulatory office. I have the fortune of also having served at the Federal Trade Commission and the Department of Justice, so we will dive into how this opinion or decision by the Supreme Court might affect those agencies as well. And now I will turn it back over to you, Peter.
Thank you. As you can see, we have a fantastic panel today, and Peter is going to walk us through the origins of this case.
Absolutely. And, I don't think a whole lot of background is needed for people on this webinar about what the CFPB is, but it is always helpful to just quickly revisit where the agency came from and where it's going and what its mission is. So it is an independent agency created by Congress after the financial crisis, and directly in response to that crisis, which does come up in the Supreme Court's decision, created to regulate offering and provision of consumer financial products and services designed to be the house, to house and collect the various laws and regulations that apply to these products, and seek to sort of make sure that they're implemented and applied in a more uniform manner. The feeling at the time, as the CFPB was being stood up, was that the regulations had kind of failed in a sense to stop the financial crisis, and needed to be refocused. So the background of the CFPB and its structure, it was established as, like I said, an independent agency. It has a single director, an officer of the United States, who heads up the bureau, who is appointed by the president and serves, after being confirmed by the Senate, serves a 5-year term. And the crux of the issue, which we'll kind of get to as we go through the presentation, is the director of the CFPB is, per the former language of the Dodd-Frank Act, removable only for cause, only for inefficiency, neglect of duty, or malfeasance in office, and that creates the structural constitutional issue that the Supreme Court ultimately addressed on Monday. Quickly doing a brief overview of the Seila Law case, began in 2017, really arose out of a CID that Seila Law received and petitioned to set aside. Petition was denied, and so they challenged the CFPB and tried to enforce it, and Seila Law challenged in response and argued that the CFPB did not have the ability to enforce its CID because of, in part, and amongst other arguments, its structure was not constitutional. Clearly and pretty directly, looking at the PHH arguments in PHH Corp v. CFPB, and really a myriad of other cases that have challenged the constitutionality of the Bureau on the structural grounds and others. So one of many, and this is the case that bubbled up. Supreme Court granted cert in October, heard oral arguments, which many of my colleagues were able to attend on March 4th, and issued the decision on June 29th, so obviously just a few days ago. Just to quickly set the stage, the argument really is pulled from two different places in the Constitution. Article 2, Section 4, which vests executive power in the President of the United States. Article 2, Section 3, that requires the President to take care that the laws be faithfully executed. From these is pulled this idea that the President has the authority to remove executive officers, and that authority should not, or only very carefully, be limited by an act of Congress. And the argument in Seila Law has been and was that the removal protections, the for-cause removal provision in the Dodd-Frank Act for the director of the CFPB went too far and provided too much insulation from the removal authority of the president. And this argument has, like I said, has been percolating and bubbling up, and created a circuit split when the Ninth Circuit and the DC Circuit found that the removable insulation did not rise to the level of a constitutional issue, did not make the structure of the Bureau unconstitutional. Fifth Circuit, not looking at the CFPB, but rather the FHFA, held that it was, and a similar structure exists there. So this created a bit of a circuit split, which found its way up to the Supreme Court to ultimately decide. Just quickly touch on this decision, and then we'll turn it over to Allison to pull others in. The court decided that the for-cause removal provision did violate the Constitution, was inappropriately and provided too much protection from the President's removal authority. However, decided as well that this provision is severable from the rest of the Dodd-Frank Act and the CFPB's organic statute, so provided that remedy, that the provision could be removed and then remanded to the lower courts to decide, as Allison noted, what essentially that means, and creates discussions around ratification, which we'll get to later in the presentation. So Allison, I'll turn the slide back to you to pull others in, and just we can spend a moment on the court's decision here.
Yeah, thank you, Peter. So the court, as everybody knows, the majority opinion, the court's opinion was written by Justice Roberts, and in a nutshell, the opinion really has two holdings. One, that this is a violation of the separation of powers doctrine, and that in fact the president should be permitted to remove the director of the agency for reasons other than so-called cause, and the enumerated list including malfeasance, negligence, et cetera. And number two, they said that the remedy for, in this particular discrete case, was to remand it back to the lower courts and to basically around the question of ratification. And this question of ratification is one that we've seen before in the CFPB context. And as Peter and others know on this call, the ratification issue came up last time with the Noel Canning decision when prior Director Cordray was appointed during an intra-session of Congress, and Noel Canning subsequently Noel Canning versus NLRB subsequently found that was unconstitutional, that appointment, and then Rich Cordray was subsequently appointed in a constitutional manner in July of 13. But between July of 11 and July of 13, there'd been a lot of things that had happened at the CFPB, so 2 years worth of activity that Director Cordray subsequently ratified with an omnibus notice of ratification in the Federal Register. And I think what you're going to see here is that same question emerge. What is the nature of ratification that the current director has to do to reaffirm or affirm in the first instance that the activities of the agency, the CFPB, especially as it relates to litigation and ongoing investigations and possibly rulemaking, that those activities, that conduct is in fact in accordance with the new constitutional regime that Justice Roberts' opinion puts forward. And I think candidly it's a little too soon to tell exactly how that is all going to shake out, but I definitely think that the question of ratification is the issue worth following. There are, of course, a couple of other aspects to the argument that were particularly, and the opinion itself, that were particularly notable. So as many know, the government itself, the CFPB, abandoned the position it had previously taken that its structure was constitutional. And as a result, as the Supreme Court sometimes does when the government changes its position, it appointed an amicus to argue the position of the government. And in this case, the amicus who was appointed was Paul Clement. As many of you probably know, Paul Clement, who is a very brilliant litigator himself, was the Solicitor General under George W. Bush. Remember hearing him speak when I was at the Department of Justice. And Mr. Clement argued that, among other things, Seila Law did not have standing. And even if the argument that Justice Roberts kind of put forward in his opinion is, he said, yes, we understand the standing argument, and the position of the court is that because Seila Law was sued in the district court to enforce the civil investigative demand, it was a defendant, that standing as to district court was not a concern, and that as to the appellate issue, well, yes, you need to have a separate basis of standing if you seek to appeal. But what the court held was that it believed that the standing issue was not a concern because, in fact, Seila Law had standing, because the question around the constitutionality of the single director removed only for cause structure was one that went to the core of any alleged injury that Seila Law had suffered as a result of receiving a civil investigative demand that it was not interested in and not intending to comply with. And so, you might read that opinion and say, well, they didn't really take head on the question of standing, but they did address it. And so that's really the holding in the case. The majority opinion deals with that issue. There's also a concurrence and dissent that's authored by Justice Thomas, to which Neil Gorsuch signs on. And essentially what that says is, look, we agree with the holding of the majority that the CFPB's structure is unconstitutional, but we don't think, we, Justice Thomas and Gorsuch, do not believe that the remedy is to remand it because it's not susceptible to ratification. And indeed, there's two separate severable components that are at issue here. One, the Bureau's ability to promulgate a CID, to enforce it, and two, this question of the director and whether she's constitutionally in place. And so how do you choose which provision is severable here, and how do you make a decision that ratification is ultimately the appropriate remedy? And what Justice Thomas essentially says is, I would just deny enforcement of the CID and argue that this isn't severable. If you take that to its natural place, he's essentially saying that the CFPB as structured can't continue. Obviously, Justice Roberts doesn't find that. What he says is everything else in the CFPB's structure is constitutional, except for that one issue of the director being removed only for cause. Now, the reason that's critical is because that's essentially putting to bed any other arguments that folks might make subsequently about the constitutional nature of the CFPB. And, myself and Jerry in particular, who were at the Office of Enforcement, have certainly seen many of those arguments in the past. And I do think Justice Roberts' opinion makes it clear that the only true constitutional issue here has been resolved. Now let's move on. And then finally, of course, the dissent is Justice Kagan writes that opinion, and she essentially goes and tracks the 1789 decision, the Constitutional Convention, and point by point, using very scholarly, detailed articles, talks about why the severability issue here is not really one that is appropriate, and indeed that the right to remove only for cause accords with the separation of powers doctrine and gives the president the right amount of authority, but also marries up that authority to what Article 1 of the Constitution, which of course gives authority to Congress, says. So her opinion is definitely worth a read as well, because if nothing else, it's a really interesting read about the history of the Constitutional Convention, and she tracks all of this back to some of the originalist arguments that animate Justice Thomas's opinion in particular. So that's the high and low of the opinion. It's definitely a really interesting opinion, a good 4th of July read. If you haven't yet finished reading it, I highly recommend it, especially if you're a con law nerd like I am. Peter, if you want to, we can talk a bit about ratification and maybe move some of the slides toward that. And then we'd like to hear from Andy and Jerry about what this means in terms of the Bureau's future.
Absolutely. And Allison, covered pretty well the sort of the ratification question, which the court sends back to the lower courts to handle in the first instance. And again, we've recently seen ratifications coming out of the Noel Canning decision, where the NLRB and the CFPB both at least for the NLRB directly, and CFPB sort of assumed that it would apply to them, had constitutional issues with the appointment of their leadership. And so once those issues were fixed, issued ratifications that sought to apply the remedy down the line to prior decisions. That issue is not one that I think is fully settled, and I do think we'll see some argument stemming from the issue of ratification. Obviously, the severance of the for-cause removal provision cures, as the Supreme Court states, the constitutional issue with the Bureau, and structurally the Bureau is sound, but it's sound as of Monday when the court ordered the provision struck. So the question becomes, what happens to all the activities that went on prior to that when the Bureau was arguably unconstitutional? And there, ratification has been and is the sort of model solution to take, have the director who's now fully constitutional and fixed up and say, I've reviewed all of these things that we've done and would have done them in that instance and would do them now. And that fixes the constitutional issue for those situations. And there are arguments, there are edge cases. I think Allison has rightly pointed out the sort of omnibus ratification isn't necessarily ironclad and isn't necessarily free from challenge. There's sort of three key points you look at when you're thinking about ratification in this instance, and that is, whether you have, you being the director of the CFPB at this point, the authority to take the action now that you're ratifying, knowledge of the material facts and decision, and whether or not you're applying a detached and considerate affirmation of the prior decision or of the prior activity, and those stem from several of the cases surrounding ratification, and I'm sure we will likely see arguments around those elements of ratification as as the Bureau attempts to move forward and as parties attempt to, continue to assert, their rights, their rights to be sort of regulated by a constitutional bureau, and if they see issues with the constitutionality or issues with the regulation, will continue to make that argument.
So one issue on ratification, you touched on it, Peter, is, there's actually two issues. One issue is whether or not an omnibus ratification gets you there. In the case of Director Cordray, you could argue that maybe it did because it was just his activities, right? So before him, there was no director. So he simply went back and said, I would have done all these things had I been the constitutionally appointed director on July 21st, 2011, when the Bureau came online. I wasn't. I am now, so I'm going to pretend that I was and go back in time and just do an omnibus ratification. Here you've got an interesting situation because you've actually had three directors. You've had two appointed and confirmed by the Senate, and then one who was acting, Mick Mulvaney, who in fact I believe is a distinction. That was a distinction that Justice Roberts' opinion made. So I think this question of ratification is actually going to get tangled up a little bit in courts, and I think you're going to see some parties that are subject of litigation and or investigations with the Bureau probably candidly make a bigger deal of this ratification issue than the law might actually allow them to do. But I do think you're going to see some additional law come out around this ratification question. Peter, I know you've spent a lot of time looking at this issue, and I don't think there's anything definitive on it, is there?
There is judicial analysis. I think that the Third Circuit coming out of the Noel Canning decision has, that those elements, but again,
right.
Agreed. I think it does, and the court notes this in its decision. Ratification is highly case dependent, fact dependent. There's and there isn't, I think, a deep body of case law on this issue to really pull clear rules from. So certainly arguments can be made. The last two bullets on the slide, obviously the immediate impact is not great, or that impactful Seila Law is going back to court to see if they can ultimately get out of the CID. So in practical terms, there's still argument to be made, and this isn't a silver bullet by any means. And it's likely, I think, to not really have too much of an impact for settled cases and decisions. If you've agreed to a consent order a few years ago, it's I think, and looking also at the administrative law judge issue, which came up a little while ago as well, another sort of constitutional question around appointments. It's difficult to really open up that can of worms and go back and say, okay, everything the Bureau has ever done is now subject to challenge, and there's a sort of a feasibility and practicality element to that as well. So, but no, I think ratification is something that we're going to see a lot of research on, a lot of articles and writing and argument on, and certainly parties and organizations that view themselves as a closer edge case. Maybe they have an argument that the Bureau does not now have authority over them, even if it may have had back when a decision was made against them. There could be those cases where there is a bit of an argument, but we saw from Noel Canning that it wasn't a huge concerted effort the same way we've seen with the actual constitutionality question, where lots of different parties and cases had challenged that and raised that. You don't see as many challenges to the Director Cordray's omnibus ratification. So I query whether sort of for practical purposes we'll see that here, or if maybe we'll just see a few of the outliers that have slight nuances that give their arguments a little bit of a boost.
I think that's right. You touched on something, and I'm going to ask Andy and Jerry in a moment to weigh in. You touched on something that I think is critical. In his opinion, Justice Roberts makes it very clear. He talks about the practicality of it, right? You can't have a situation where you completely erase everything an agency that's 9 years old or almost 9 years old in a few weeks, has done since its inception. You can't take the 18 enumerated consumer finance laws that it's charged with enforcing in addition to its own indigenous UDAP authority and revert them back to their other agencies from which they were born or from which they came. So there is a practicality component to this as well with the ratification. And speaking of practicality, I'm curious because I happen to think that the true impact of this is more political than it is administrative or legal. Andy and Jerry, you were both at the Bureau, as was I at the beginning when the agency was started. And so you're very familiar with some of the conversations that went on around the politics of a commission versus a single director, the politicalization of the agency itself at its inception. And I'm curious, Andy, from your perspective as a regulatory expert, and Jerry, from your perspective as an enforcement expert, what you guys see here as the paths forward as it relates to this decision in the CFPB.
Sure. So this is Andy. I'm happy to start and turn things over to Jerry. From a regulatory perspective, one of the issues here is how the Bureau will make policy moving forward, how it will go about particularly discretionary rulemakings where essentially the authority was vested entirely in the director. The director was driving the ship, so to speak. And there was, at least when I was there, which was during the Obama years, and, with Rich Cordray in place. So you had a friendly president and director, a director who was appointed by that president, and in many ways their views were aligned, but still very little involvement from direct involvement from the White House in setting regulatory agendas and setting the initiatives that the Bureau was following or its direction in specific rulemakings. And that, that spans from implementing the Dodd-Frank Act, the slew of mortgage rules that the Bureau unleashed in 2012, 2013 that I've worked on, to even discretionary rulemakings about arbitration and payday lending and so on. There was a degree of independence that was just recognized, and it was recognized by the White House, and there wasn't a lot of political pressure put on the director. And the same goes for Congress. We would get inquiries from Senator Warren or Senator Brown's offices or even some Republicans who had an interest in the rules that we were doing and, wanted to, weigh in or, offer suggestions or what have you. But those were just advisory. There was never a real sense of political pressure being put on the staff to do things a specific way. And largely that came because the director was independent and the director was intentionally put there with that level of authority and autonomy. I think in terms of the path forward, that likely will change. It will vary depending on who the director is and who the president is, of course. More of a nexus to the White House and to politics and to the director. And that could also cross over into the Senate and the House of Representatives, depending on the level of influence that they want to exert and the level of influence they have within the White House. I expect to see more political involvement in the rulemakings, and that will be whether there's a Democrat in the White House and a Democratic appointee, or a Republican in the White House and a Republican appointee. And what we almost certainly won't have is a crossover like we had during the end of the Cordray era, where we have a Republican president and a holdover Democratic appointee or vice versa. It seems like the likely conclusion here is whenever there is an election, there'll be a change. And if there's a change in political parties, likely a change in leadership. And, that could be both good or bad, depending on your position. I think what it will certainly do is make things less predictable and less stable. Some of the statutes that are enforced, I'll turn it over to Jerry to speak more about this. The statutes of limitations can go back 5 years. So, you can reach an equilibrium with the CFPB on an issue, or, basically follow a best practice that's off the CFPB's radar for, 4 years under one director and then have things change the next. There are pros and cons to that. And, Jerry, I turn it over to you from the enforcement standpoint and also just to talk about the ideas of forming a commission, if you want to jump in.
Thanks, Andy. Of course. So let me step back to the enforcement context and some practical concerns. I look at this in sort of two buckets when you're looking at enforcement. I get a lot of calls from clients who say, should I do something immediately right now? And my answer is, well, let's talk about how it impacts your either investigation or ongoing litigation with enforcement. When it comes to ongoing litigation, there is a gut reaction to, hey, could we go file a 12b6 motion? Could we file a motion to dismiss because the director has not ratified our litigation yet, or our case? Of course, as soon as you do that, it's highly likely that if it was litigation started during Kraniger's administration, that she's going to file a ratification right away, and you've just wasted a lot of resources and time and maybe made things more adversarial than necessary. And I put it sort of in the same camp with investigations. Could you not respond to the CID and stop everything because Director Kraniger has not ratified your investigation yet? Of course, if the CID was issued during her tenure, it's highly likely she will ratify that CID. So there are some exceptions if you're sort of in a holdover investigation or litigation from the Cordray time, and you think there's a chance that Kraniger was sort of pigeonholed into continuing this matter forward, but would like to have some avenue to get out of it. So there could be, some situations where you may want to have a discussion with the enforcement office about whether ratification is appropriate or not. With regards to the commission, Andy raised some great points. When the Bureau was first started, Raj Date, one of the first sort of interim director, would refer to the CFPB as an airplane being built while it was being flown. And the need to have one person at the helm was extraordinarily important because when there was a hole in the plane, it needed to be plugged quickly, or when there was an electrical outage, it needed to be fixed immediately with quick decisions. That is no longer the case. The Bureau, as Allison pointed out, has been around almost a decade, and a commission would bring some stability. And I say that having worked at an agency that was governed by a commission, at the Federal Trade Commission, for example. There were a lot of former FTCers who came to the CFPB, and we all used to say to everyone, the single director is great now, but you're really going to wish for a commission in the future. And I think the commission benefits, quite frankly, if Congress does move that way, it benefits the staff and it benefits the industry and it benefits consumers. A commission will provide more stability. It will remove some of the pure political actions from the Bureau, whether it's under the former director, Rich Cordray, the acting director, Mick Mulvaney, Director Kraniger, or some future director. A commission will more likely than not militate towards some type of consensus having to be formed, whether it's a 3-person commission, a 5-person commission, but we could see that occur. And as we'll talk about later, though, I don't think a commission is without its perils in light of this decision handed down by the Chief Justice of the Supreme Court, and especially in light of the concurring opinions of Justices Thomas and Gorsuch. And so with that, let me move it over towards the enforcement activities.
Thanks, Jerry. Thanks, Andy. So one of the, the questions that we are all getting in our respective practices as to our clients is, what does this mean for my litigation that I have with the Bureau? Or what does this mean for an investigation that's pending? Or what does this mean in the future? And, Jerry and I and Jonathan have all been, I'm sure, fielding these questions and kind of, looking at the world and trying to make sense of this opinion in light of those things. And Jonathan, if you can start us off and kind of give us a sense of, how the world looks for you, given this decision and your views on enforcement and investigations. And then I'd love to hear from Jerry, and I'll weigh in as well.
Sure, and thank you. And I think, from 100,000-foot level, one has to look at this in the context of both what is the individual item one is considering and analyzing, as well as also what are the politics and policy goals of the current CFPB in relation to what it is that's being analyzed. And there are several different buckets that can be analyzed, as well as also very isolated situations. You have scenarios where you have past enforcement actions and litigation that is closed, signed, sealed, delivered, judgments rendered, the consent orders signed, and the like. And those, in some cases, are from the Cordray era, and some are from the Mulvaney-Kraniger era. Those are likely, as has been discussed, are likely moot. They're already in place, would be unchanged, except for instance, somebody who might petition now to have some sunset provision inserted into their consent order or to activate it early. In some cases, there's a number of orders from the Cordray era that have sunsets that take place around now, give or take months or a year or so. You also have, though, this looming question as to what's going to happen with a large bucket of actions that may have been taken previously in former administrations or in the present administration that are still pending. There are any number, about a half dozen to a dozen cases that are being litigated. In some cases, there's stays that courts have imposed waiting for this decision. And, in other instances, they've been prosecuted pretty heavily by the current administration, even if they were brought by the former. And, each one of those has some different dynamics. Ultimately, there is the potential that Kraninger could choose to either ratify or perhaps, has been suggested already, but not put a fine point on it, not ratify, to take some slightly different tact, maybe is no longer boxed in. I think we have to think of ratification as not necessarily something that's done as a blanket matter for purely expediency, but also as a matter of politics and policy initiatives. You also have, though, there's a fair number of actions that have been taken during the Mulvaney and Kraninger years that are also closed. They've been settled or rulemakings that have been issued and finalized. Those obviously are unlikely to be subject to a constitutionality argument and the most likely to be ratified. So you have a bunch of different buckets. The one thing that's for certain, though, is that organizations, particularly defendants in lawsuits or targets of investigations that have their backs against the wall and have been hanging their defense, or at least one defense, on questions of constitutionality, no longer have that arrow in the quiver, and now need to be in a position where either they play other cards or perhaps instead of seeking to delay, maybe even put the gas on, particularly in light of recent polling numbers and the potential for a change in administration, and now a definite likely change in director on January 20th if there is a new administration. It's important to consider the timing aspects to all this. And much like some of these pending rulemakings that are still looming out there, like debt collection and others, that have the potential for Congressional Review Act activity, and that's a whole nother webinar. You've got some stuff, too, that's been pending for quite a long time where the clock is now ticking.
Those are great points, Jonathan, about timing. And there's a certain counterintuitive issue here, which I think you're right to bring up, which is all of a sudden the instinct to delay, the intent to delay is kind of reversed, and now there may be some intent to move things up pretty quickly, especially if it looks like in November, Joe Biden wins, and ultimately in January when he takes office or sometime thereafter, he appoints a replacement for Kraninger who's quite a bit more aggressive than her office has been, and candidly, I think her Office of Enforcement has been quite aggressive. I haven't seen a real reticence to prosecute cases or to pursue investigations. So I think that's really terrific advice and really thoughtful advice and somewhat counterintuitive as well. Hey, Jerry, what are your thoughts on, how this impacts investigations, enforcement actions, et cetera?
So I think, Allison, you and Jonathan have covered it, and there will be probably a marginal effect on ongoing enforcement investigations or litigation. To your point earlier, I do think parties may make a mountain out of a molehill as it comes to ratification, because that's not something difficult to do. One thing that I would like to touch on is the potential effect on other agencies. When you read the court's opinion, it's very interesting because the Humphreys Executor case, upheld the multi-member commission that was the Federal Trade Commission and removal for cause. And this current opinion, the Seila Law opinion, seems to, at least on the concurring opinions of Justice Thomas and Gorsuch, seems to open the door and practically beg for someone to challenge the for-cause removal provisions at the Federal Trade Commission in its current state. And so I raise that because there is a possibility, excuse me, there is a possibility that commissions may have to be removable at the will of the president when you look at the unitary executive theory. And so it will be interesting to see how that plays out and whether the FTC, the SEC, or other commissions are challenged. Again, the remedy may be just striking those provisions in their enacting statutes that make those agencies have their commissioners only removable for cause. It's not clear that is going to occur, but it's very clear that the court has left open a window to move towards narrowing the administrative state, so to speak.
Yeah, I agree with all of that. So one other thing that I think is really important to keep in mind, to Jonathan's point about expediting things and kind of anticipating a November that may result in a significant change in leadership at the Bureau, is this, you kind of put that in tandem with the COVID pandemic and the Bureau and other consumer finance law enforcement agencies' intense focus on the way that consumers are being treated and in retrospect will have been treated during the pandemic, when there is a credit crunch, when there are a lot of people losing their jobs and losing steady sources of income, and when you have instances where there's been a concerted effort on the Bureau's part, for example, to monitor the way that credit reporting is happening, or local jurisdictions concerned about ongoing collections efforts of debt. And I think if you couple those things, plus the Seila Law case, plus the likelihood or possibility of a new administration in November, you're going to see a CFPB enforcement office that is potentially not only very active, but taking pretty aggressive positions on things going forward. Some of the work that I think hasn't happened as much under Mulvaney and then Kraneker's regime is a pushing of the CFPB's UDAP doctrine. One of the tasks that Cordray took on when he became head of the agency after having been head of enforcement, when Jerry and I were working there, was the idea of building out the CFPB's indigenous UDAP doctrine, its prohibitions against unfair, deceptive, or abusive acts or practices. And there was a very concerted and deliberate effort to take cases that would push the outer bounds of that doctrine in court, because of course the way any agency is going to build its doctrine is through common law, notwithstanding the interest in a lot of, there's been a lot of push to get rules written. Those rules are probably never going to get written, or at least not anytime soon. So the pushing of UDAP doctrine happens through bringing cases and to some extent through consent orders. You haven't seen as much of that with Kraneker's enforcement office, although she hasn't been shy about prosecuting companies, but she hasn't pushed as much on the UDAP doctrine front as I think Cordray did. You may see a reversal of that instinct as well, and you may see in November, if Biden's elected, he appoints somebody who is very interested in building out the UDAP doctrine. And so I do think that, coupled with the pandemic, coupled with this decision, are some really make for some real interesting possibilities and possibly really game-changing possibilities in the enforcement office in terms of aggressiveness and interest in pursuing novel and maybe more far-reaching theories of UDAP authority and Bureau jurisdiction. The other component of this that I think is really yeah, go ahead. I'm sorry, Jerry.
Well, I was going to add that, it's interesting because Rich Cordray, during his administration, some of the philosophy seemed to be, well, let's push the legal limits, and if the court tells us no, well, that's the court's job. Whereas others may say, let's do everything in moderation. And so it will be very interesting, if the current administration stays in place, Kraneker's tenure will continue until a new directorship. If Vice President Biden prevails and takes the presidency, then to your point, a lot will depend on the person that is put at the helm of the CFPB and whether there is a very far swing back to the left or a swing just a little bit back to the left. But in all cases, it seems to be that the pace at the Bureau may pick up more than it is now.
I think that's right. I was going to say.
Yeah, I had one thing I wanted to add as well. Thanks, Jerry. Another area that's if there is an area that enforcement and even supervision has fallen off a little bit under the Mulvaney and Kraninger terms, it's fair lending. Fair lending was a key area of focus under Cordray. There was, a massive ramp up to regulate the indirect auto industry. There also, were new HMDA rules that were published under for mortgage companies to report that really are a data mine for fair lending enforcement. And there hasn't been a whole lot of activity to date. And largely that's because Mulvaney and Kraninger scaled back the fair lending office. If you recall, fair lending was moved under the front office out of what used to be called OFLAO, Office of Enforcement and Fair Lending. And that is, if there is a change in director in the next year, especially in this environment where, social justice is really the issue du jour, there's a lot of civil unrest. I think there's a lot of interest in fair lending, and I would expect to see fair lending enforcement become front and center once again. And, there very well may be some bad data in there for a lot of companies that have they've been operating under the assumption that the Bureau has been sidelined and isn't coming after them as aggressively as it was when Cordray was in charge. So that's an area to watch, and, especially for specific industries, an area where there could be a lot of concern.
Thank you. And Andy, I was going to jump to you next anyway because of your substantial expertise in the regulatory world and your firsthand knowledge of how rulemaking could be impacted by the Seila decision. And I'm curious about what your thoughts are concerning that, as well as supervisory and guidance activities of the Bureau, both formal and more informal interactions that the Bureau has with regulated entities.
Sure, happy to talk about both. So I think in terms of supervision, I would expect little to no change other than potentially a change in director and a shift in policy like we've been talking about. To be honest, supervision hasn't changed all that much in the last few years either. And there hasn't been as much of a focus on specific issues that Director Cordray focused on. I was just talking about fair lending, but also some areas like RESPA, haven't been as high a priority. That can change, but supervision policy will generally stay the same. In terms of rulemaking, there is a full rulemaking agenda. The Bureau has an open proposal right now for qualified mortgages, which is going to be very impactful to the mortgage industry. It's unclear whether a change in director would change that. The proposal's open now. The framework has already been put out there, and unlikely that a new director would come in and do things completely differently. But there certainly could be a more aggressive rulemaking agenda, again, with more influence from politicians, from the White House, from the Congress, given that the director is going to be more sensitive to political pressure under this new environment. I think if anything changes on the rulemaking front, that will be it. I don't think there's a whole lot of risk to past rulemakings being undone or, having to be subject to challenge. Jerry mentioned this before, the prevailing view at the Bureau has always been that ratification of something like a rule is fairly easy to accomplish. If they needed to, they could simply republish everything. But, there will be, I think, there's likely going to be some changes in policy moving forward, and much of that will depend on who wins the election in November. And so I'll put that
thank
back.
you. Yeah, that's all really helpful. I think that, Jerry, you talked a bit about this and the impact that this would have on other agencies as well. And I know, Peter, you've looked at some of this too. And one thing I note that I think is helpful to think about when we talk about other agencies is the state attorneys general, I believe, and I don't remember if they wrote an amicus brief into the Supreme Court, but I know the state attorneys general, the Democratic ones at least, were pretty vocal about maintaining their support for the structure of the Bureau. And I think that the vocalness, if you will, gives us a little bit of a line of sight into what a new CFPB enforcement regime would look like in tandem with those state AGs. And Jerry, Peter, Jonathan, Andy, I'm curious what your thoughts are about that idea.
That's a great point, Allison. The state attorney generals are big fans, at least in certain states, of the CFPB, and even in other states where, let's just say, the politics might not align with the current administration, whatever that current administration may be. It seems to be that all states take action when certain classes of consumers are impacted by unlawful activity, and that's generally service members, older Americans, and students. That seems to cross or transcend party lines. And why that's important is because in the current administration of the CFPB, we have not seen a significant number of cases, or as many cases, that have been brought in coordination with states, attorney generals, and the CFPB. And I believe there were more during the Cordray administration, and it will be interesting to see if that changes because, of course, the state's attorney general's offices have the authority to file UDAP cases and to file under certain regulations under the CFPB. And so to the extent that that provides states with more avenue to obtain relief for consumers or take more or take quicker action, they may do that. Peter and Jonathan, if you have any thoughts on this, please feel free to add in.
So,
Jerry, you're absolutely right. The power of the state AGs now, using the UDAP authority of the Bureau, is now validated. If it was ever in question, it's certainly validated now. And to the extent, though, that a director wants to help guide what that sort of the jurisprudence and the policy positions around UDAP are, and to the extent it's been tamped down in recent years and maybe amplified far more in the Cordray years, so it's been a bit of a yo-yo, you could certainly see the cases that have been brought or will be brought in the future by state AGs to continue to use the UDAP authority as an aggressive tool. I think what's really interesting is that you have this split in state AG activity for the last 4 years. Certainly, we've seen an uptick in investigations and interest in light of the change in administration from more progressive state AGs. But you also have, a whole host of state AGs who have really tried to avoid using the CFPB's tools, as well as also even embracing the CFPB. In some cases, on this very constitutional argument has been part of their talking points. So the political dynamics here change considerably. Those who were in support of the Bureau now find themselves, again, in support of the Bureau, but not defending any longer necessarily the single director structure. And then on the other hand, you've got a single director structure now that's been validated by the courts and gives the president unlimited authority to really direct the future of the organization. I think really, though, to close out on that thought, I don't think there was anybody who would ever question that President Trump, if he wanted to, would have, in one way or another, asserted authority over the Bureau. It's now just validated by the court. I think the real open question will be is how does this play out in a new administration, if there is one?
Yeah,
and piggybacking on
I agree
that,
with all of that.
Yeah. Just quickly on the UDAP question and the situation we have now, where the director is removable at will by the president. States do look to the federal government and to the CFPB for resources, to bring resources to investigations that the states can then join. And another thing we've talked a lot about and seen is as the CFPB slowed down on aggressive UDAP enforcement, some states, tried to pick up, and you get this concept of mini CFPBs forming in different states to attempt to fill what they perceived as a gap there. And more of a question than anything, but how does this affect the movement toward a mini CFPB in California or similarly in New York, where now maybe under the Red administration, the states could depend on resources and join investigations that the CFPB was engaged in, but maybe not in 4 years from now. And so does that flexibility and lack of stability mean that states continue to move forward with mini CFPBs, or is there a pullback given that maybe if the director changes that frequently, then maybe they don't need to. But really more of a question than a conclusion there.
Those are terrific points, though. You know, my experience is that nothing goes away. So once you form a mini CFPB or you have the political inclination to do so, it's not, I don't necessarily think that that's going to go back. I think what you're going to see is you're going to see that those mini CFPBs, if you will, still formed, assuming the politics works, coupled with potentially a new CFPB enforcement regime that's quite a bit more aggressive than the current one. We have a few minutes left, and I want to make sure we get to a few other questions and concerns that we suspect the audience has, including considerations for parties facing the CFPB right now in light of Seila. And we've touched on some of this, but Jonathan, I'm wondering if you can give us a few other tidbits of information, and then I'm going to ask our panel to go around and say one thing that they're looking at post-Seila law as kind of the round-robin closure.
Yeah, I think the reality is if you're facing the CFPB now and something that is not finalized, you have to recognize that who you're sitting across the table from is who you're sitting across the table from. There's no longer the ability to say and argue and take it to court that who you're sitting across doesn't have the authority to be there. That being said, that dynamic, again, as we've touched on so many times today, has the potential now to change essentially much more rapidly, certainly not necessarily to 2023 if there's a new director and if there's a new administration. And so that has to be taken into account. If you're midstream with the CFPB and you've been making arguments or in enforcement situations, in an investigation, or even in an exam where they've been taking a policy position on a position on the law, given your particular facts that you don't like, again, there is a question of, are you being held to some standard that perhaps the current Bureau did not necessarily believe in? And is that at the staff level or is that higher? Is there the potential for forbearance? We certainly have seen that play out where you've seen, there's been plenty of enforcement actions where the staff have been very aggressive. Even the Bureau itself has been aggressive, although on the penalty side, for instance, maybe not as aggressive. And so there's been some forbearance there. You also have policy questions, though. So there are open rulemakings and hopes for rulemakings on a whole host of issues where the current Bureau has been largely favorable to business and also not necessarily looking to make waves. So you have an entire debt collection rulemaking that's still pending that took essentially about a 180-degree turn under the current administration that's still hanging out there, hasn't been finalized yet. Does that get finalized, and what type of undoing could potentially happen to that if it's done in the fall and you have a new administration in the spring? So there are open questions there. I think, again, it depends on the context. And I think at this point, we've now gone from macro and looking at the holistic state, unconstitutional, don't have to worry about it, and just throwing that against the wall, to now having to look much more granularly.
So thank you. I want to ask Jerry to give us the CLE code and also say our final closing statement for today. And I want to just thank everyone for joining us. Hey, Jerry, if you can go ahead.
Sure. The code is Seila, S-E-I-L-A. Not a surprise to anyone. And, in closing, the only thing that I would like to add is that it has infamously been said that elections have consequences. And I think that is how this decision will play out in the future. Again, we thank everyone for joining us. We know this is a trying time. We appreciate your patience. And please feel free to follow up with any one of us if you should think of any questions that you would like to have answered. We wish you all a happy 4th of July weekend as well.
Thanks, everybody. Thank you.